The Honourable David Parker.
Thank you, Mr Speaker. David Shearer, in his contribution on the first reading debate, said that, as he understood it, offenders from Australia who have been convicted and returned to New Zealand following conviction are arriving in New Zealand without particulars being provided to the New Zealand government at the time as to what the offences were that they were convicted for in Australia, and perhaps sometimes when they're arriving. Now, I want to hear from the government if that is the case, because there are only two explanations of that. Either there is irresponsible behaviour on the part of the Australian government, firing convicted criminals back to New Zealand without telling the New Zealand authorities enough information so that New Zealand authorities can protect New Zealanders in the case they need to be, or there has been absolute incompetence by the New Zealand government not getting that information that could have been available if they asked early enough. Those are the only two explanations I can think of, Mr Speaker, and I want to hear if the Minister of Police interjects that there might be many others. Take a call and tell us what's happening. We'll wait for the committee stage, he says. Well, it would be nice if one of your members could actually take a call and address these important issues now. Mr Speaker, I want to turn to another issue that, this bill was dropped on us. The first time we saw the wording of this bill in detail, the outline of it had been provided by Amy Adams to Jacinda Ardern, but in terms of actually seeing the legislation in written form, which has changed even in the last day, as I said in an earlier contribution, was after question time today at about 3:30. We then had the first reading, and we're all preparing for that. We're now into the second reading. It's still only, it's not even yet 6 o'clock, and I've had a chance to read through it a little bit further, and I'm concerned that we're ousting the jurisdiction of the court to overturn an improper determination by the Commissioner of whether someone meets the criteria of being a returning prisoner that would trigger the provisions under Section 24, which says that returning prisoner is then subject to standard release conditions. Clause 22 says that the Commissioner makes, Clause 17 sets out the criteria to be applied to where the Commissioner must determine that the person is a returning prisoner, and then it sets out what should be in a determination notice, and then it says someone can apply to the Commissioner of Police to review that determination. That's set out in Clause 22 of the bill, and then it says at Clause 24, Part 28 of the bill, that a court may vary or release those vary or discharge those release conditions, except that at Clause 28.2 it says a court must not discharge a standard release condition with effect from the date that is less than 6 months after the date of the determination notice. Now, I want to hear from the government as to whether they think they are ousting the jurisdiction of the New Zealand courts to say that the Commissioner was acting illegally and applying the wrong criteria during that 6-month period. Because I tell you what, if I'd come back from overseas and I'd had a traffic conviction or something, and I'd been imprisoned in some foreign country or under threat of I had been convicted of an imprisonable offence overseas, and it's not just Australia that this legislation applies to, and I got back here and I was slammed with one of these notices that said that I was all of a sudden subject to these notices, and I thought it was wrong. I'd actually want to go to the court and challenge it. And I wouldn't be happy with only having the right to go to the Commissioner of the Police and say, please trust me, I'm a good criminal, let me off. I think if the effect of this legislation is that we're ousting the jurisdiction of the court to consider these things in that period, then that is poor legislation and that goes too far. Now, I'm not sure that that's the effect of Clause 28.2 of the bill, but it does say a court must not discharge a standard release condition with effect from a date that's less than 6 months after the date of service of the determination notice being given. So it is arguable, I suppose, that during that 6-month period the court doesn't have jurisdiction. It may be that that you can take a judicial review route. I'm not sure. It's not clear from this bill. This reinforces the point that the Labor Party made, which is we should have a two-track process here. We should be passing this bill under urgency because we've got no choice but to do it in order to protect people now, and it should have a drop-dead date of a year, a termination date. On the same day, we should be passing an identical bill through only the first stage, and that bill should commence on the termination date of the bill that's a short-term fix, and it shouldn't have a drop-dead date, but it should go to select committee, and then we can sort out through submissions from the Law Society, from the Sensible Sentencing Trust, although I don't often listen to them, they don't often have much good sense to pay. They do have a right to make submissions, from Rape Crisis, from the civil liberties groups, from all of the civil society who've got an interest in these things. Mr. Speaker, that is how a proper government would deal with this conundrum, but the government's refused to do it. Mr. Speaker, finally, I also hear that some of these people are getting back to New Zealand with no money, no ties, ending up sitting on the Wind's doorstep the next morning because they've been delivered into the hands of New Zealand without any support being provided to them. And I would hope that as the government realises that this problem needs to be addressed, they also look at what they need to do to minimise the prospect of those people reoffending and to maximise the chance that they can be meaningfully reintegrated into our community in a way that means that they don't end up reoffending against other New Zealanders. Mr. Speaker, I again return to this point as to whether we've got the balance right between protecting people, New Zealanders, from returning criminals. We're not clear that we've got that right in this legislation. We don't have time to properly consider that under urgency. That should be being considered on the parallel track in the bill that should go to Select Committee. Similarly, whether we're going too far in respect of some people who ought not to be caught up in this, or truncating their ability to go to court to test whether they are being properly caught up on it, that too could have been sorted out in the parallel track process of the second bill that could have gone to Select Committee today. And I think it just shows a complete lack of proper process on the part of the government, that they would not only leave it so late to bring this legislation to Parliament, but having forced it upon Parliament, they won't actually agree to us letting that occur. The idea that the government would itself review things in 2 years...
Interrupt the honourable member. The time has come for me to leave the chair for the dinner break. This debate is interrupted, and I shall resume the chair at 7:30.